Hi friends, welcome back to the channel. We're back to read another case from my dad's law book, Criminal Law Case Digest, available on Amazon, Barnes & Noble, and by direct email to me. So this time we will talk about some cases about the assassination of people in the government. So we'll pick one case today. It is from Title 8. Title 8 is titled When You Strike a King. Cases of assassinations of and attempts on the lives of high-ranking government officials. My dad quoted Shakespeare in his book Richard II. For God's sake, let us sit upon the ground and tell sad stories of the death of kings. We are going to read chapter 46, and here are the facts. Laredo has long been harboring a strong resentment against Mayor Noe for the killing of Laredo's brother by a brother of Mayor Noe a few years back. While with the mayor that evening monitoring some illegal gambling activities in a nearby barangay, that's a small town, he was heard muttering, "I'm fed up." Arriving at the municipal building 30 minutes thereafter, Laredo, appearing to be very tense and in the verge of tears, took an Armalite rifle from one of the policemen and fired a burst of gunfire at the mayor. The latter died of 8 gunshot wounds on different parts of the body. 1 hit him on the face, 1 on the chest, 4 on the abdomen, and 2 at the back, each of which was enough to kill the mayor. After the assailant Laredo was disarmed, he was asked why he shot the mayor, and he said, "It's now even." He further replied, "He was after my life. I am a poor person, and what would happen to my family if I would be killed? He is fortunate to be rich." The .38 caliber pistol of the mayor was found beside his body with the casing still tucked on his right waist. It was locked or on safety mode, although there was a bullet inside the chamber. Laredo admitted killing the mayor but pleaded self-defense. He said that on arriving at the place, the mayor approached him after getting off the motorcycle, and with his .38 pistol pointed at him, the mayor uttered, I will kill you," and that fearing for his life, Laredo fired his service Armalite rifle at him, killing him. Question: what is the crime committed by Laredo? You have 4 choices. A. Murder qualified by trickery. B. Murder qualified by evident premeditation. C. Homicide. Or D. No criminal liability under the doctrine of self-defense. So before we reveal the correct answer, we will discuss the dialectics provided in the book for this case. The killing is not qualified by alevosía or trickery. The attack did not come without warning, and there is no showing that the mayor had absolutely no opportunity to defend himself or to escape. Where no particulars are shown as to the manner by which the aggression was commenced or how the act which resulted in the death of the victim began and developed, trickery cannot be established from mere suspicions drawn solely from circumstances prior to the killing. Neither is the killing qualified by evident premeditation. To establish evident premeditation, it must be shown that there was a period sufficient to afford full opportunity for meditation and reflection, and a time adequate to allow the conscience of the actor or the perpetrator to overcome the resolution of his will. In other words, the essence of evident premeditation is that the execution of the criminal act must be preceded by cool thought and reflection upon the resolution to carry out the criminal intent during the space of time sufficient to arrive at a calm judgment. The footnote for that sentence was from People versus Bautista, Supreme Court rulings number 613 278. In this case, less than an hour lapsed from the time Loreto uttered, "I am fed up to the moment he shot the mayor at the municipal building. It is definitely not sufficient lapse of time to give Loreto an opportunity to coolly and serenely deliberate on the meaning and consequences of what he planned to do. There is no self-defense. For self-defense to prosper, the accused must positively show that there was a previous unlawful and unprovoked attack that placed his life in danger and forced him to inflict more or less severe wounds upon his victim, employing therefore reasonable means to resist the attack. This defense is perched on proof of unlawful aggression on the part of the victim. Unlawful aggression presupposes an actual, sudden, and unexpected attack, or an imminent danger thereof, and not merely a threatening or intimidating attitude. It is an indispensable condition for the justifying circumstance of self-defense. In other words, there can be no self-defense, whether complete or incomplete, unless the victim has committed an unlawful aggression against the person defending himself. This case, Loreto. Simply put, unlawful aggression is indispensable, it being the ingredient for self-defense. The fact that the mayor's super .38 pistol was retrieved beside the mayor's fallen body may give semblance of truthfulness to Loreto's tale of unlawful aggression. However, it loses its credibility against number one, the possibility that the gun was thrown out from the holster of the mayor as the mayor fell to the ground, and number two, the fact that the mayor's pistol was locked and on safety mode when it was recovered at the crime scene. The nature and number of wounds inflicted by an assailant are constantly and unremittingly considered important, which disprove a plea of self-defense. The wounds found on the body of the victim were telltale signs that there was no unlawful aggression from the victim. Any one of the 6 bullets that found their mark on the frontal portion of the mayor's body was enough to immobilize or repel any unlawful aggression which he said was undertaken by the mayor. From the moment the 6 wounds were inflicted on the mayor, the supposed aggression had certainly ceased. Loreto no longer faced any danger to his life and limb. His continued offensive stance made him the aggressor. When an unlawful aggression which has begun no longer exists, the one making defense has no right to kill or even injure the former aggressor. So in this case, Loreto had no chance to really meditate or plan on killing the mayor. So there's a possibility that he intended to kill, but because there was lack of time for him to really plan anything like a sudden attack where the mayor wasn't aware that he was around. Like if you look at the backstory of these 2 people, Loreto and Mayor Noe, Mayor Noe would definitely be careful around Loreto because his brother had killed Loreto's brother a few years back. So there is really some tense situation happening there, and no doubt the mayor would know that Loreto might hurt him in any case or in any situation. So, and the mayor is actually prepared to defend himself. But in this case, also, Loredo can't say self-defense because, like the um, facts of the case says, the mayor's pistol was on safety mode and locked. Even though it has a bullet in the chamber, it shows that at the time that Loredo decided to um, use a firearm and kill the mayor had no intentions of like killing Loredo. So Loredo can't use self-defense as a defense. So the answer is actually C, homicide, because there's no evident premeditation, and it seems like Loredo was acting impulsively um, based on his emotions at the time. So he was just thinking of really, maybe getting even with the mayor, but there was no time for him to plan like an attack. So what would you say the about this case? Is it really homicide or is it premeditated murder? So, or is it one of the choices, murder qualified by evident premeditation? You can mention your comments by you can mention your answer to this case by commenting below. And so there's a lot of like facts, details to consider when the court is deciding whether it's murder or homicide. And I think the homicide would be aggravated by the fact that he actually killed a person in a government position. There's a law on that, like how the punishment goes. So for this case, we're going to discuss how homicide and murder are different crimes in Philippine law. In the Philippines, homicide and murder are considered as two separate and distinct crimes, punishable under the revised penal code. They are both crimes against persons. To be able to distinguish the two crimes, there are a few elements that must be determined. So, the crime of homicide is defined and punishable under Article 249 of the revised penal code. Article 249 describes homicide, in which any person who, not falling within the provisions of Article 246, shall kill another, without the attendance of any of the circumstances enumerated in the next preceding article, shall be deemed guilty of homicide and be punished by reclusion temporal. I'll also enumerate the different kinds of punishments, and that includes reclusion temporal. The elements of homicide are the following. A person was killed. B, the accused killed him without any justifying circumstance. And C, the accused had the intention to kill, which is presumed. And D, the killing was not attended by any of the qualifying circumstances of murder or by that of parricide or infanticide. In order to distinguish it clearly, we're going to discuss how the Philippine criminal law defines murder. Murder is defined and penalized under Article 248 of the revised penal code as amended, which reads, Article 248, murder. Any person who, not falling within the provisions of Article 246, shall kill another, shall be guilty of murder, and shall be punished by reclusion perpetua, which is life imprisonment, to death if committed with any of the following attendant circumstances. First, with trickery, taking advantage of superior strength with the aid of armed men and employing means to weaken the defense of the victim or of means or persons to ensure or afford impunity. Number two, in consideration of a price, reward, or promise. Number three, by means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a railroad, fall of an airship by means of motor vehicles, or with the use of any other means involving great waste and ruin. On occasion, number four, on occasion of any calamities enumerated in the preceding paragraph, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or any other public calamity. Number five, with evident premeditation. Six, with cruelty, by deliberately and inhumanely augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. Generally, the elements of murder are 1. That a person was killed, 2. That the accused killed him, 3. That the killing was attended by any of the qualifying circumstances that we had just enumerated under Article 248, and 4. That the killing is not parricide or infanticide. Those are two other types of killing. So, as we have discussed or read, murder has a lot of elements that needs to be considered um, before we actually classify the killing as murder. And in future notes, murder is also, qualified by justifying circumstances, which may lessen the punishment for the murder. There's aggravating circumstances as well, which can increase the level of punishment for the murder. So we will discuss that in our future videos. So in the case of Loreto and Mayor Noe, it is mentioned quite consistently that the killing was only classified as homicide because there was no evident premeditation. So just to explain what is evident premeditation in under Philippine law, it is the execution of the criminal act that is preceded by cool thought and reflection. Thus, there must be proof showing when and how the accused planned and prepared for the crime. So for Loredo's case, let's just circle back. While he was with the mayor monitoring some illegal gambling activities, he was heard muttering, "I'm fed up," like full of emotion. This is Loredo. Arriving at the municipal building 30 minutes after, Loredo, appearing to be very tense and in the verge of tears, suddenly took an Armalite rifle from one of the policemen and fired a burst of gunfire at the mayor. The latter died of 8 gunshot wounds on different parts of the body. So when Loredo was disarmed and calmed down, he was asked why he shot the mayor, and he just said, "It's now even." He further replied, "He was after my life. I am poor, and what would happen to my family if I would be killed?" So these were all just sudden emotions and mental decisions or like thoughts that he had that made him act on impulse. So acting on impulse actually doesn't qualify as evident premeditation. So thank you for joining me. This is just one of the many cases that we'll be discussing in future videos. Please comment down below, and you can request for any cases that you want to discuss for your review for your criminal law exam.